L'audience est ouverte. La Cour se réunit aujourd'hui pour entendre le second tour d'observation orale de la Guinée équatoriale sur sa demande en indication des mesures conservatoires. J'appelle à la part Sir Michael Wood. You have the floor, sir.
Thank you, Mr. President. Mr. President, members of the Court, after some initial comments, I shall respond to what Professor Pele, my friend and my colleague, said yesterday about prima facie jurisdiction. I shall be followed by Maître Tchikaya, who will deal with the reality of the criminal proceedings in France. Professor Kamto will reply to what was said yesterday on the risk of irreparable damage before the final decision of the court. And the agent of Equatorial Guinea will conclude with our final submissions. Mr. President, we heard a great deal yesterday from our friends opposite. Fact, law, rhetoric, and plain prejudice about jurisdiction and the merits. But we are not at the stage of the merits, nor are we at a possible preliminary objections phase. This is the provisional measures hearing. It does not seem as though our colleagues from France are paying much heed to your practice direction 11 or to the law and practice on provisional measures. The speeches yesterday were remarkable for what they did not say. They did not seem to contest that Equatorial Guinea has acquired ownership of the building located at 42 Avenue Foch in Paris. They did not contest that the building is now used as the embassy of Equatorial Guinea in France. While attempting to rely on probabilities and statistics, they did not deny the possibility that French courts, those courts that they made a point to stress they have no control over, even to the extent of hinting that they might have difficulty giving effect to a provisional measure requiring suspension of the proceedings, that those French courts will indeed push ahead with the proceedings against the Vice President of Equatorial Guinea, including by issuing another arrest warrant and eventual condemnation. Instead, they presented you with what they titled a chronological record of an abusive process. This was reminiscent of the attitude the French courts have adopted towards Equatorial Guinea and its high representatives. Indeed, Professor Pele adopted, with apparent approval, the term habillage juridique from the Ordonnance de Renvoi. Thus, to impugn the motives of states is unacceptable in international relations. Both as regards the facts and the law, our friends opposite would have you decide now matters that are for the merits. This is, for example, clearly the case with respect to the entitlement of the Vice President of Equatorial Guinea, charged with national defense, to immunity ratione personae, a possibility they seemed carefully not to rule out completely. France has indeed recognized in the past, on several occasions, in the Sixth Committee, for example, that such immunity is not limited under international law to the Troika alone. The legal question of delineating the scope of the narrow circle of holders of high-ranking office in a state, to whom, in international law, it is firmly established that immunity ratione personae is due, is perhaps, in Professor Asensio's words, such a sensitive and complex question. As such, it is obviously not fitting for final decision at a provisional measures stage. The same may be said of the fact-intensive questions relating to the Vice President's particular office and functions, and the relationship between the Vice President and other senior officers under Equatorial Guinea's constitutional arrangements. Such questions clearly relate to the merits. At the present stage, all that need be shown is that Equatorial Guinea's claim to such immunity is at least plausible. I believe we have done that, especially by reference to the Court's own statements of the law in arrest warrant in Djibouti and France. Mr. President, I now turn to the question of prima facie jurisdiction. Professor Pelle yesterday did not really seek to address the criterion of prima facie jurisdiction relevant at the provisional measures phase. Instead, he launched into a full-scale attack on the jurisdiction of the court, such as one would expect at a preliminary objections or merits phase, after an exchange of detailed written pleadings. There was precious little recognition on his part that the condition for the indication of provisional measures is prima facie jurisdiction, and that the court need not satisfy itself in a definitive manner that it has jurisdiction as regards the merits of the case. Professor Pelle's arguments yesterday were wide of the mark. He began by making a series of points that bore no relation to what we had said. At no time did we suggest that jurisdiction flowed from the importance of the principles involved. At no time did we invoke the 2004 United Nations Convention as a basis of jurisdiction or as applicable law. At no time did we suggest that there was jurisdiction over questions of general or customary international law, except insofar as such jurisdiction flowed from the two treaties we actually relied upon, the Palermo Convention and the optional protocol to the Vienna Convention. At no time did we try to extend the application of the jurisdiction and immunity of diplomats to the Vice President. Professor Pelle suggested yesterday that our claim regarding the inviolability of the building depended on our claim regarding the immunity of the Vice President, and that because we have said that the two issues are related, the same is true for the basis of jurisdiction to rule on them. That is not the case. The two issues are indeed closely linked in the criminal proceedings in France, but for purposes of the jurisdiction of this court, Equatorial Guinea has invoked separate bases. Mr. President, members of the court, Equatorial Guinea's claims for respect for the principles of sovereign equality and of non-intervention, and the rules of state immunity that derive from these principles, in particular the immunity from foreign criminal jurisdiction of certain holders of high-ranking office in the state, and the immunity from execution of state property, are based on the terms of Article 4 of the Palermo Convention. The object of this provision is, as appears from its title, to protect the sovereignty of states parties to the Palermo Convention. As the legislative guide prepared by the United Nations explains, and I quote, Article 4 is the primary vehicle for protection of national sovereignty in carrying out the terms of the Convention. Article 4 establishes a treaty obligation to respect the principles of sovereign equality and of non-intervention when implementing the Palermo Convention. This provision has the effect of incorporating these fundamental principles of the international legal order into the Convention. The principles of sovereign equality and the non-intervention encompass important rules of customary or general international law, in particular those concerning the immunities of states and their officials. As this court said in the jurisdiction and immunities of the state case, and I quote, the court considers that the rule of state immunity occupies an important place in international law and international relations. It derives from the principle of sovereign equality of states, which, as Article 2, Paragraph 1 of the Charter of the United Nations makes clear, is one of the fundamental principles of the international legal order. The same may be said of the rules on immunity of holders of certain high-ranking office in the state. As a consequence, Article 4 of the Palermo Convention requires states to respect the rules concerning the immunities to which states are entitled before foreign courts when applying the Palermo Convention. Being embodied in the principle of sovereign equality, the rules concerning the immunities to which states are entitled before foreign courts are binding on states when applying the Palermo Convention. It is worthwhile recalling in this context that a chamber of the court found in the Elsie case, with respect to a treaty provision, that it found itself unable to accept that an important principle of customary international law should be held to have been tacitly dispensed with in the absence of any words making clear an intention to do so. Our friends opposite have argued that Article 4 of the Palermo Convention does not constitute a real obligation, but merely a directive générale, in accordance with which other provisions of the Convention must be interpreted. They refer in this connection to oil platforms. I would make 2 points. First, the treaties and specific provisions in question are entirely different. In oil platforms, it was Article 1 of the Treaty of Amity which was in question. That provision was broad in scope and its wording was vague, which led the court to conclude, after it carefully analysed the treaty as a whole, that it simply fixed an objective. Article 4 of the Palermo Convention, by contrast, does not set out the objective of the Convention. It is Article 1 of the Convention which could be seen as fixing an objective for the purposes of interpretation. Article 4, for its part, establishes a clear and specific obligation that prescribes what states must and must not do, not in general and for all purposes, but in applying the Palermo Convention. The second point, and this is crucial, the wording of Article 4 is clearly drafted in terms of an obligation. The reading put forward by France yesterday goes against that clear wording and would have the effect of depriving the article of any effet utile. The Palermo Convention does not oblige states to respect the principles of sovereign equality and non-intervention generally. It imposes on them the obligation to respect those principles when applying the Convention. This is to ensure that no disturbance would be caused to international relations as a result of implementing the Convention. In other words, to prevent precisely a situation such as the one that has compelled Equatorial Guinea to turn to this court. I would make 3 points. First, in entertaining criminal proceedings against the Vice-President of Equatorial Guinea, France is prosecuting an alleged crime, the criminalization of which is explicitly required by Article 6 of the Palermo Convention. It is also clear that France is seeking to implement other provisions of the Convention. For example, Article 12, confiscation and seizure, Article 14, disposal of confiscated proceeds of crime or property, and Article 18, mutual legal assistance. Regarding mutual legal assistance in particular, it will be recalled that, as also mentioned yesterday by the agent of France, the French judicial authorities addressed a request for mutual legal assistance to Equatorial Guinea on 14 November 2013. That request made explicit reference to the Palermo Convention. Second, it is clear that France considers the law on the basis of which it is prosecuting the Vice President, namely Article 3241 of the French Criminal Code, as implementing legislation for the Palermo Convention. Evidence of this may be found in a Senate report of 2002 concerning the ratification of the Palermo Convention, where French legislators were of the view that the French legislation on money laundering was already in conformity with the Convention and thus was a sufficient basis for its implementation. Third, the fact that the French judicial authorities have not, as a general matter, referred explicitly to the Palermo Convention, though they did, as I've just noticed, when approaching Equatorial Guinea, is not only natural and understandable, but it's also irrelevant. International law does not require states to refer explicitly to the international obligations they seek to carry out in their domestic law. In the absence of an obligation that would require them to do so, states are free to choose the way in which they give effect to their international obligations domestically. Finally, Mr. Chairman, I turn briefly to prima facie jurisdiction under Article 2 of the optional protocol to the Vienna Convention on Diplomatic Relations. Professor Pelle's argument here got rather lost in his slideshow of somewhat dated images. But disentangling the argument, he seems to be saying that the building at 42 Avenue Foch did not form part of the premises of the mission of Equatorial Guinea on what he termed the critical date, a notion that has not been further explained, that they never acquired in law the quality of premises of the mission, and that the building was, or perhaps is, a private property. And his argument continued, because they are not premises of the mission, Article 22 on inviolability and the Vienna Convention as a whole did not apply to them. Therefore, he said, there is no jurisdiction under the optional protocol. As Professor Pelle knows, I'm the first to admire Cartesian logic, but there is something rather unconvincing about this particular example. Mr. President, we could, and perhaps we will, have interesting debates about the facts and the law concerning whether and at what date, insofar as a precise date is relevant, the building became premises of the mission within the definition of that term in the Vienna Convention. But one thing is clear already. A dispute over such matters is a dispute arising out of the interpretation and application of the Vienna Convention within the meaning of Article 1 of the optional protocol. As such, under Article 2, the Court has jurisdiction if certain conditions are met. Those conditions are met, as we explained in the application instituting proceedings. France has not argued otherwise. Professor Pelle referred in this connection to the legality of use of force cases, where the Court said that it cannot limit itself to noting that one of the parties maintains that the Genocide Convention applies while the other denies it. In the present case, the Court must ascertain whether the breaches of the Convention alleged by Yugoslavia are capable of falling within the provisions of that instrument. Recalling the essential characteristic of genocide, the Court concluded that it did not appear that the bombings which form the subject of Yugoslav's application entailed the required element of intent towards a group as such. Mr. President, the question whether 42 Avenue Foch is or was premises of the mission within the meaning of the Vienna Convention is of a wholly different nature to the question whether the bombing of Serbia amounted to genocide. Given the positions of the parties in the present case, the diplomatic status or otherwise of 42 Avenue Foch raises serious legal and factual issues that will need careful analysis on the merits. Unlike the allegations of genocide made by Yugoslavia, the violations of the Vienna Convention alleged by Equatorial Guinea are obviously capable of falling within the provisions of the Vienna Convention. Finally, Mr. President, Professor Pelle went so far as to urge you to remove the case from the list without hearing the parties further. He once again cited the legality of use of force cases. Once again, those cases were wholly exceptional. In our submission, there can be no basis whatsoever for the action suggested by Professor Pelle. Mr. President, members of the Court, that concludes what I have to say. I thank you, and I request that you invite Maitre Tchikaya to the podium.
I thank Sir Michael Wood